Place yourself on mute if you are not addressing the court.
Are we live on YouTube yet? Pat, your microphone is turned off.
Yes, sir, we're on.
Okay. Good afternoon. Welcome to County Court at Law Number 6 Remote. It is approximately 2:40 p.m. on Monday, the 16th of November, 2020. I'm Judge Wayne Christian, representing the Bexar County Criminal District Attorney's Office as Assistant Criminal District Attorney Jeff Wright, who will participate in all cases, and CSCD Supervisor Susan Gross, who I will swear at this time. Ms. Gross, will you please raise your right hand? Do you swear the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
Okay, we have several cases set today. These are all motions to revoke probation or motions to adjudicate guilt and revoke community supervision. Mr. Trevino, let's go ahead and take up Ms. Cantu at this time, if that's okay with you.
That's okay with me, Judge. We got everything worked out already.
I've got cause number 623067, the state of Texas versus Claudia Cantu. And this is a motion to enter adjudication of guilt and revoke community supervision. Representing the defendant is Mr. Fernando Trevino. Once again, representing the state is Mr. Jeffrey Wright, and representing the Bexar County CSCD is Ms. Susan Gross, who has been previously sworn. Ms. Cantu, I'm going to ask you to identify a couple of documents before we actually get into this. The first one is a document entitled Defendant's Consent to MTR Hearing by Video Conference. Is this your signature on this document, ma'am?
Yes, sir.
Thank you. And I also have a signature of, I guess, the previous attorney, Mr. Michael Zamora. Would that be correct, Mr. Trevino?
It is, Your Honor.
All right. And it's okay with you that we just leave Mr. Zamora's signature on there as consenting to MTR hearing by video conference, although it is clear on the record that you are the current attorney of record. Is that fair?
It is. I am the current attorney of record, and I concur with the statement.
The second document I have Ms. Cantu identify is entitled Trial Court Certification of Defendant's Right of Appeal, which is marked as an adjudication of guilt following a deferred adjudication, and the defendant has limited right of appeal. Is this your signature on this document, Ms. Cantu?
Yes, sir.
And it also reflects the signature of Michael Zamora, who's the previous attorney. And Mr. Trevino, any objection to us allowing Mr. Zamora's signature to continue? You're welcome to sign these documents near his name after this hearing is over, if you wish, if you want to make it squeaky clean.
No objections, Your Honor. I'll be happy.
Fair enough. This is an uncontested motion to adjudicate and revoke community supervision. How does the defendant plead?
Guilty.
No. You plead true or not true, and you're pleading true.
Oh, I'm sorry. You said what?
You plead true or not true, but you're going to go ahead and plead true.
Okay, true. I'm sorry, Judge.
Thank you, ma'am. Court accepts your plea of true with an explanation. Ms. Gross, would you please advise the court and the parties of the status of Ms. Cantu's probation, please?
Yes, her reporting has been good. We last saw her on November the 2nd of 2020. She's paid $1,037 towards her fees, has a balance of $495, and is current on her fees at this time. We have no record of any of her 48 hours community service having been completed. She has completed DWI education, victim impact panel, and CATSNP, and she's had 3 negative drug tests. She's currently on Smart Start Mobile testing 6 times per day, and she has 7 skip tests and 1 high BRAC on October the 2nd of 2020 at 11:27 p.m. of 0.029. Her officer is recommending that she be placed on SCRAM for the duration of probation. This is her 4th violation for Smart Start Mobile violations, and it's only resulted in 1 motion to revoke due to the COVID virus. She has no criminal history.
Okay, State, do you have a recommendation on Ms. Cantu?
Yes, Judge, we would recommend that you deny the state's motion, continue the defendant on probation, and alternate in conditions for Scram for 1 month, and then after that 1 month, then put her back on Smart Start Mobile.
Mr. Trevino, what are you requesting?
Well, that's the agreement I made with the state, Judge, and I'm happy with that. However, my client has both the Scram and the load device, the Smart Start Mobile. I was wondering if we could, while she's on the Scram, return the other unit, and then when she gets off the Scram, put it back on.
Okay, I'm looking at her records. It appears that on or about 2 October 20 at 11:27 p.m., somebody, whoever blew in the machine, blew a .029, but the CSCD department thinks it's some other person and not Ms. Cantu testing that day. Is that possible?
It's very possible. Anything's possible.
Is that going to happen anymore?
It won't, Judge. She's scared. I talked.
Ms. Cantu, who did you have blowing the machine at that time?
You said October 2nd or some other time?
2nd at 11:27 p.m. So that's at night.
Yes, that was actually my coworker. That was a bad idea. Shouldn't have done it.
Are we going to do anything bad like that again, or is that the end of your day? All right.
Yeah, that's the end of it.
Mr. Trevino, as you're well aware, the law does not require me to follow any agreement you and Ms. Cantu may have made with the state. However, in this case, I'm willing to go along with it except for one part. I'm going to put her on Scram, but it's going to be subject to my approval whenever it comes off. It's not just going to be in a month or so. My normal plan on these things is when someone gets on Scram, they do it for 60 days. If there are no violations, I put them back on Smart Start Mobile. Susan, how much longer does Ms. Cantu have on probation in the unlikely event I have to stay on probation?
She is on until July 15th of 2021.
All right, so we have a long time on Ms. Cantu. And has she, did you say she's finished catnip?
Yes.
Not working. Do you have any other suggestions on what else we can do to change the way she thinks about alcohol?
Sadaf?
Well, that would be a little probably radical. Trevino's viewpoint if I were guessing, but.
Yeah. No, I think she's doing actually pretty well considering where she works. There's alcohol around her. She's only messed up once.
Where does she work? For those of us that have no idea.
Twin Peaks, Your Honor.
I'm sorry?
Twin Peaks, Your Honor.
Oh, great place. I'll take judicial notice of Twin Peaks.
Thank you.
DWI research opportunity. Ms. Cantu, do I have your word you're not going to drink any more alcohol while you're on probation with me?
Yes, you have my word, Judge.
Ask your attorney what that means if there's a problem in the future, and he'll explain it very clearly, unequivocally for you.
Okay.
It'll go ugly.
Ms. Cantu, the court accepts your plea of true to all conditions on the motion to revoke probation with an explanation. I deny the state's motion to revoke your deferred adjudication probation or to continue on deferred adjudication probation with all prior requirements and no sanction at this time, although I have the authority to put you in jail for 30 days to get your attention. Will that be necessary?
No, Judge, it won't.
Good answer. Altering amending conditions, adding Scram within 10 days. As soon as the Scram device is active, we'll take the Smart Start Mobile device off. So you're only paying for Scram and not both of those things. But I want an overlap so that we don't have a time period that might.
She has the Scram device on, Judge.
Oh, she has it already on? Wonderful.
Yeah. How long have you had it on, Claudia?
I don't think it's been a week yet.
Okay.
It's on.
We have no violations in a week, right?
Yeah, none.
You're not going to let somebody else wear your Scram bracelet, are you, ma'am?
No, it's gonna stay on, and I'm gonna stay sober.
Okay. Basically, you win. This will probably be the last time, so let's not have any more little conversations like this in the future. Fair enough?
Yes, it's fair.
If there are any more issues, we're going to be talking about inpatient rehab. And Fernando, I'll let you explain that to her. I'm running out of options.
I will.
We already had her on 6 blows a day on Smart Start, and then she violated while she had 6 blows a day on Smart Start, hence the Scram device. So that's the last option I have before jail or inpatient. So y'all can chat about that. But today, you win. So well done.
Yay.
Judge.
On Ms. Cantu.
I'm sorry?
Anything further from the state or the defense on Ms. Cantu?
Yes, Judge.
Good luck, Ms.
I've got
Cantu.
a couple of things. Ms. Cantu, tomorrow, your officer, probably in the afternoon, will be receiving the order to turn in your Smart Start mobile. So they will send it to Smart Start. So probably on Wednesday, you'll be able to go turn it in. You don't have to blow in it because you've got the Scram device, okay?
Okay.
And then
Awesome.
also, if you have not heard from your officer by 5 o'clock tomorrow, you need to call your officer, okay? Your officer is gonna send you some paperwork to sign. And if you don't sign that paperwork, then you're gonna be right back here, okay?
Okay.
Any
Then
questions?
what else does she need to do? Community service is the only other thing that we have open at this time?
Yes, Your Honor.
And for Fernando, she's welcome to donate $10 an hour to a court charity like Family Violence Prevention Organization or Wounded Warrior Organization. If she'd rather do it that way, otherwise she can start working on her community service hours. My understanding is there are organizations you can do that from home during the pandemic by answering the phone or something for them. So y'all can look at that.
Okay, Judge.
Best of luck, man. Thank
Thank
you.
you.
Okay. We ready on Mr. Soto's case? Just Mr. Boyer's with us today. I think he saw him a minute ago. There you go.
Yes.
This is cause number 545555. State of Texas versus Joel Soto. This is first amended motion to enter adjudication of guilt and revoke community supervision. Mr. Soto, I have a couple of documents for you to identify your signature on for me. The first one states defendant's consent to MTR hearing by video conference, which purports to have your signature and Mr. Boyer's signature on it. Is this your signature on this document, Mr. Soto?
Yes, sir.
And Mr. Boyer, is this your signature on this document?
Yes, Your Honor.
Thank you. The next document, Mr. Soto, is entitled Trial Court Certification of Defendant's Right of Appeal. And the one I have is not marked correctly. The one I have is marked in a plea bargain case, and the defendant has no right of appeal. This is not a plea bargain, MTR. This is an adjudication of guilt followed by a deferred adjudication, and the defendant has a limited right of appeal. Do you agree, Mr. Boyer, that that's what the law does?
Yes, Your Honor, I agree.
So Pat, whoever gets a copy of the actual live document needs to make sure those modifications are changed. Is this your signature, Mr. Soto?
Yes, sir, it is.
And Mr. Boyer, is this your signature on this document?
Yes, Your Honor.
Thank you. Okay, there's an uncontested motion to revoke probation on the motion to enter adjudication of guilt and revoke community supervision out of the defendant plea.
True.
True. Here's an explanation. Fair enough. Mr. Gross, what's the status of Mr. Soto's probation plea?
Judge, Mr. Soto never reported to probation. He signed his conditions on June 20th, 2017, and we never ever saw him again. He never paid anything. He has a balance of $832. He never did any of his 24 hours of community service. He never did his F class, but he did manage to get arrested and charged with a new possession of marijuana. This case did expire 12/20 of 2017. He has no criminal history, just the new number one that he's charged with. And the probation department is recommending revocation.
Jay, do you have a recommendation?
Yes, Judge, the state recommends you grant the state's motion, sentence the defendant to whatever time he has, giving him credit for time served and satisfying a judgment. This was just a Macy's theft, and then the new charge that he picked up is a possession of marijuana. I looked at it, it's 11 grams. It's something that we wouldn't proceed on anyways now. The only reason it's been filed is because it happened in 2017. I think giving the defendant a theft conviction would be sufficient punishment in this case, since he has no criminal history. And next time he picks up a theft of any amount, it will be a Class B misdemeanor.
He had 11 ounces of marijuana?
Grams.
Wow.
It was grams, not ounces.
Well, grams, excuse me. Okay. And Ms. Gross, does Mr. Soto have prior offenses? Seems like I looked at something.
No, he only has the charge that is pending, which is the possession of marijuana.
Mr. Boyer, is there a reason why Mr. Soto never reported?
I mean, he might be able to answer this better than I can. No transportation and no money at the time.
No transportation or money since 2017? You only had 3 years to report.
Yes, sir.
Do you have anything to say about that, Mr. Soto? I'm running out of options with you.
I was a child at that time, and I am now owning up to my mistakes, and I just hope to make right of what I've done wrong throughout this time.
Susan, do I have the authority to revoke his deferred adjudication probation and continue him on probation if I wanted to?
Yes, sir.
You can revoke the deferred and put him on regular, yes.
Mr. Soto, if I were to do that, is there anything you tell me that's going to give me a warm, fuzzy feeling you're really going to do what I tell you to do this time?
Yes, sir. I'll go through it 100% and make sure that I'll finish it on time and with correct payments.
How old are you now, sir?
22.
Okay, are you working, going to school? What are you doing?
I'm working right now at the moment, sir, and I am in February. I'm also applying to get my driver's license and getting back into school hopefully around that time.
What school do you anticipate going to?
Northwest Vista for English teacher and hopefully interior designer.
Good answer. Right, you have any information on what type of property was stolen or attempted to be stolen by Mr. Soto back when this offense occurred?
I can look at it, Judge, but it was Macy's and it was, let's see.
Clothes, not a Ferrari or something?
I don't know if Macy's sells Ferraris.
It was a pair of clothing around that time for a dance recital that I had that night. I didn't have any money, so I thought maybe I can try to get a pair of pants and ended up where I am.
Yeah, it was 2 clothing items, Judge.
And we all agree there's a class
Yes.
B, right? Here's how it works, Mr. Soto. The longer it takes me to write this down, the better off you're going to be. So better hope it takes me a while here to get this figured out.
Judge, I sent you the TIC dismissal on the POM on Adobe Sign.
Everybody that's not talking, turn off your microphone, please.
Mr. Soto, mute your microphone.
Yes, ma'am.
Okay, back on the record. Clause number 545555, State of Texas versus Joel Soto. The court accepts Mr. Soto's plea of true to all conditions on the motion to enter adjudication of guilt and revoke committee supervision with an explanation. I grant the state's motion to revoke his deferred adjudication probation, adjudicating guilty of the offense of theft, $100 to $750, sentence him to 6 months in the Bexar County Jail, probated for 1 year. Assess a $500 fine plus court costs. 48 hours community service, the ATSE anti-theft course, DOEP course, weekly UAs. You're gonna test positive for marijuana if I test you for a urinalysis test this week, sir?
I'm sorry?
Give you a urinalysis test this week, are you gonna be positive for marijuana?
No, sir.
No?
No.
Right. Good answer. Give him a UA this week sometime, Ms. Gross.
Yes, sir.
Yeah. I consider True Dawkins on the motion to adjudicate and revoke probation. I grant the state's motion to revoke your deferred adjudication probation. I adjudicate you guilty of theft, 100 to 750. I sentence you to 6 months in the Bear County for 1 year, 48 hours of community service, $500 fine plus court costs, ATSE course, DOEP course, weekly urinalysis test starting this week. Give him a UA this. Taking into consideration clause 548170 is granted, it shall be dismissed. I'm also going to assign him 30 days in the Bear County Jail as a sanction. However, I'm going to hold it in abeyance. So if anything goes wrong, your fault, my fault, nobody's fault, he's got an automatic 30 days in jail. Do we all understand that?
Yes, sir.
Soto understands the seriousness of the circumstances. You put you on your way to jail for 6 months right now. You understand that, right, sir?
Yes, sir, I do.
Well, I think it's helpful that you haven't robbed any banks since we had this issue, and it's been a while, so that's good news. Anything further from the defense on Mr. Soto?
Nothing further, Your Honor.
Yes, Your Honor.
Yeah, go ahead.
Mr. Soto, somebody will
Yes,
be
ma'am.
with you within the next 48 hours to set up a Zoom orientation with you. If you do not hear from anyone within 48 hours, you need to contact two people. Number one, your attorney, and number two, the probation department. And I will give you their phone number, 210 335 7200.
Okay.
And you need to ask for intake. So if you haven't heard from anybody by the
What was
close
it
of
again?
business, 210-335-7200, and you need to ask for intake. If you don't hear from anybody by 5
Okay.
o'clock on Wednesday, you need to call your attorney and you need to call the probation department and ask for intake. It is your responsibility to get these documents signed. Do you understand?
Yes, ma'am.
Okay, Mr.
All right,
Soto,
if you-
Mr. Boyer, I will have to send an application and a new data sheet. I will do that as soon as we're finished. And it needs to be done as soon as possible so that it can get probation, okay? Fill out all the data sheet. They need that.
Yes, ma'am. It will be.
Yeah, don't leave any blanks. And if you fail to follow through and get this paperwork signed, then you're gonna be right back here looking at going to jail, okay?
Yes, ma'am. Will it be emailed
Yes,
or
just
mailed?
like the other paperwork. It'll be just like the other paperwork.
Okay.
And as far as the probation department, they will either email you or they will call you at the phone number that you're gonna put on the form, okay?
Yes, ma'am.
All right, if you have no further questions, I'm done.
One more thing, our office number is 210-335-2156. If you don't get a call you think you're supposed to get from the probation office, if you call them back and they never call you back, worst case scenario, first you call your lawyer and then you call our office and tell them that you can't get up with the probation office. I don't want any more problems with making sure you're in contact with the probation department. Do we understand each other, sir?
Yes, sir.
You can call your lawyer at 3 in the morning. He doesn't mind a bit. No problem whatsoever. Isn't that right, Mr. Boyer?
I don't know about that, Judge, but
All right. Good job. Another one. I don't know how you keep doing this. Good luck, Mr. Soto. He's still eligible for early termination. If he does well, Mr. Boyer, bring it to my attention. When he gets everything done, we'll talk about cutting him loose. Fair enough?
Yes, Judge.
All right. Good luck, Mr. Soto.
Yes, sir.
I've got Mr.
Thank you, sir.
Olivares next. And Mr. Lopez. I saw Mr. Lopez's cute little face a minute ago. This is cause number 627244, State of Texas versus Joseph Philip Olivares. This is a first amended motion to enter adjudication of guilt and revoke community supervision. It is uncontested. Representing Mr. Olivares is Mr. Ray Lopez. And representing the state once again is Mr. Jeffrey Wright and the CSE.
Where's the volume? There was an amber alert. And
Where
now
we
I
getting
can't
that?
hear very well.
Oh, okay. Mr. Olivares, the first document I need you to identify is one entitled Defendant's Consent to MTR Hearing by Video Conference, which purports to have your signature and your attorney's signature on it. Is this your signature on this document, sir?
Yes, sir.
Thank you. And Mr. Lopez, is this your signature on this document?
Yes, Judge.
Thank you. The next document we're going to identify is entitled Trial Court Certification of Defendant's Right of Appeal, which is marked as an adjudication of guilt following a deferred adjudication, and the defendant has limited right of appeal. And is this your signature on this document, Mr. Olivares?
Yes, sir.
And also your signature, Mr. Lopez?
No, Your Honor, I did not sign that document in this case. I
I've
believe
got
I just signed the right of the participation via Zoom. We have not signed any additional documents.
my document copy it has your name typed on it, and it's got like two initials looking things. Is that how your signature goes? RL?
It is, Judge.
Well, anyway, if you haven't signed it yet, please confirm that you agree with this document and that you'll sign it after we finish the hearing. Fair enough? At some point?
Yes, Judge.
All right, all good. Okay, on the first amended motion to enter adjudication of guilt and revoke community supervision, how does Mr. Olivares plead?
I have not had a chance to talk with him, Judge. I've not had a chance to talk with the prosecutor. I have no idea how he intends to plead, or if he wants to request a contested hearing.
Olivares, have you seen this document entitled First Amended Motion to Enter Adjudication of Guilt and Revoke Community Supervision?
No, sir, I don't believe I have, unless it's the one that I signed, but I had to skim over it really quickly. I was hoping to be able to get a moment recess with my attorney.
I think that's what we're going to have to do. Ray, how come you haven't had a chance to talk to your client before now? You just get appointed recently, or what happened?
Yes, and there's a lot of discovery to go through. He's also got 2 new cases that were coming. So I just received that this morning. He's got 2 new cases I believe are set in December.
Okay, well, obviously the state's not going to go forward on trying to prove up 2 new cases as allegations. Is that correct, state?
On this MTR, probably not, but I mean, I don't even think it's alleged on, oh no, it's alleged on the first amended, but there's other allegations.
I have not seen a copy of the MTR yet, Judge.
Do this. Pat, would you send Mr. Olivares and Mr. Lopez into a chat room, and they can come back when they're finished?
Mr. Olivares and Mr. Lopez, I will.
Could I have the state email me a copy of the MTR? I have not received it yet. And any subsequent amended MTRs that were filed in this case, I've not received any of them.
Susan, what would be the quickest way to do that?
He needs to give me his email so that I can send it to him.
rlopez@raylopezlaw.com.
I'm sorry, one more time slowly.
rlopez@raylopezlaw.com.
Mr. Lopez, you can go back to room 2. I believe your client has already gone there.
I'll send it to you.
Thank you.
Okay, when y'all are finished chatting, Ray, just come on back on and we'll notice that you're there, and then we'll take you up at the appropriate time.
Sorry to bother you. How do I get to the different room? How does that work? I've never used this format before.
You should, on the bottom, it should have join. Go all the way to the bottom.
And I see a mute, stop video, participants chat, share
Go in.
screen, record.
Break room. Do you see a break room?
Is it on the bottom bar?
Yes.
No, I don't. I just see a chat.
Open more. Open more. On the bottom, more, and there should be a break room. Go into there.
It says leave, reactions, record, share, chat, participants, stop video, and mute.
Pat, I believe there was invited for Oscar Rodriguez, was the wrong person.
Oh, sorry.
I'm not sure if he got the right, if my client got the invite.
Okay.
All right,
And administrator is yours, Ray? Okay.
That's my client. Yeah.
Hold on. Hold on. There you go.
Oh, great. Thank you so much.
Okay. There you go. Sorry.
Okay, let's take
Confusing. Too many Oscars.
State of Texas versus Amanda Piano. Cause number 586927, and we have Ms. Alice Warburton as the attorney. Representing the state once again is Mr. Jeffrey Wright. Representing the Bexar County CSED is Ms. Susan Gross. Ms. Villano, are you with us today? I see you. Good. Ms.
Yes,
Villano,
sir. Sorry.
I'm reading two documents I need you to identify for me. The first one is entitled Defendant's Consent to MTR Hearing by Video Conference, which purports to have your signature and your attorney's signature on it. Is this your signature on this document, Ms. Villano?
Yes, sir.
And Ms. Warburton, is this your signature on this document?
It is, Judge.
Pat, I notice on the copy I have of this document that the defendant's printed name area does not have the defendant's name printed in it, and that needs to be corrected. Signature certainly. So that's okay. The next document I have is entitled Trial Court Certification of Defendant's Right of Appeal, and it is marked as a revocation of the defendant's community supervision, and the defendant has the right to appeal the court's action revoking the community supervision, but not the underlying conviction. Is this your signature on this document, ma'am?
Yes, sir.
And also, Ms. Warburton, is this your signature on this document?
I believe so, Judge, yes.
And this is uncontested motion to revoke probation. This is the fourth amended motion to revoke community supervision. How does the defendant plead?
True.
Your Honor, I do have issue with this. Is Ms. Villano's third time before the court. So I know that it says fourth amended, but this is her third time here with us today on an MTR. So I just wanted to clarify, this would not be Ms. Villano's fourth chance. This would be her third.
Ms. Warburton, you are correct, but this is the fourth time that we've had to change the MTR that was filed.
I understand that, which is why I am not actually contest, otherwise I would have a right to contest and have 10 more days. I just want to, I do understand that. I just do want Judge Christian to know that this is not a fourth chance. This is a third. We don't want to put Ms. Villano in an unfair position in that regard. So yes, other than that, I just wanted to note that. Please continue, Your Honor. I do apologize for interrupting.
Okay, and you, my understanding is this is an uncontested motion to revoke probation, and this is her third violation report, is what you're trying to make clear to me. So both of those are correct?
That is correct, Judge.
All right. So on the fourth amended motion to revoke community supervision, which in reality is her third problem, correct, Ms. Warburton? How does she plead?
True to one of the number twos with an explanation. Some of the failure to reports are not true, Judge.
How about true to condition, and I'm going to call it 2A as an alpha. The first number 2 alleged on it, which says on or about the 16th day of November 2019 in Travis County, Texas, the defendant, Amanda Villano, did then and there consume alcoholic beverages in violation of condition number 2. Would you like to plead true with an explanation to that one?
That's true. That was my birthday. I'm sorry.
Did you understand what I asked you, Ms. Warburton?
Yes, Judge. I believe the defendant did plead true. Yes.
All right. So you're going to plead true to what I call 2A. There's no A on the actual fourth amended motion to revoke community supervision, but that's the first number 2. And for the record, I'm identifying it as such. So Ms. Villano pleads true to condition 2A, and with an explanation, of course. Ms. Gross, would you please advise the parties and the court what the status of Ms. Villano's probation is?
Judge, Ms. Villano has performed very poorly on probation. She had an original sentence from April 15th of 2019 to April 15th of 2020, a period of 1 year. She had not successfully completed everything and had requested an extension, and that was granted so that she could take care of all of her obligations to the court. We have not heard from her since January 22nd of 2020, in which she was reporting by mail. She missed her last 6 months of reporting. She paid $414 towards her fees. She has a balance of $1,269. She completed 11.5 of her 48 hours of community service. She had 3 positives on drug tests. 2 were for alcohol via the Smart Start mobile, and she admitted to it, and 1 positive for marijuana. She did complete DWI education, victim impact panel, and CATSNP. This is her 3rd violation report, 3rd motion to revoke. She has 1 prior possession of marijuana, which was dismissed. This case did expire July 14th of 2020, and she is on Smart Start 4 times a day. Last report, she had skipped 29 times and had 2 high BRACs. The first one on November 16th, 2019 at 0.027 at 6:50 in the morning, and on 12/21/2019, 0.028 at 6:55 a.m. And the defendant has been in a lockout since February 21st, 2020.
So Judge, if I may, I have communicated with you about this defendant, and she was told by her Travis County PO, rightfully or wrongfully, just not to bother anymore, because, you know, just don't bother with COVID. There's no way you're gonna, I mean, there's nothing that's gonna be able to do and save you now. That being said, she did do more community service than is reported. She did complete all of her courses. Yes, Judge.
What community service did she perform, and where did she perform it?
Did you say Salvation Army, Ms. Villano?
No, Goodwill.
Goodwill.
Is that some sort of sub-organization of the Salvation Army? Good luck.
Yeah. Yes, sir.
Goodwill, Judge.
Goodwill, Your Honor.
What were you doing for community service? What did they have you do?
Hang up clothes, clean the restrooms, stuff like that. Just.
Okay, how many hours total do you recall doing for the week?
Excuse me, sir.
Yes, how many hours do you do?
I can't hear.
How many hours do you think you did, Ms. Villano, was Judge's question.
Oh, well, 11.5 is what they accounted me for. 11 hours. 11 and a half hours.
Okay. Judge, I thought she had done. Additionally, Judge, I think that it is worth noting, Your Honor, very seriously, that on Ms. Villano's 2nd MTR, and Judge, I can't stress how important this is. 2nd MTR, all of the parties were in agreement that Ms. Villano might be struggling with some addiction, and she was to go to some. We were in agreement that she would need outpatient services. I was fine with it. Ms.
You're
Gross.
fading in and out. This is the co-reporter.
Okay. Oh goodness. Is this better?
You need to mute your microphone if you are not speaking to the court right now, Galaxy A01.
And even Amanda, why don't you mute too? And just unmute when you have to talk. Okay. And then, Your Honor, I cannot stress this enough. On her 2nd MTR, this is so important, Judge, Ms. Gross, the state and I were all in agreement that Ms. Villano would be a good candidate on her probation if only she did not have addiction issues. She was willing to admit to those issues, take responsibility for her alcohol struggle, and do outpatient services. Unfortunately, Judge, you were not here. And so her second MTR was heard in front of Judge White, who, God bless him, ignored everybody and said, I'm just going to extend you 3 more months, little lady, and don't drink anymore. And so, of course, I and nor Ms. Villano was in any position to argue with Mr. White, but I think that we all had a feeling that without those outpatient services last time, that this would in fact happen again. So even though, Judge, that this is Ms. Villano's 3rd MTR, and yes, a lot of time has gone by, a lot of that is to do to COVID, and that is not Ms. Villano's part. I communicated with you right at the cusp of COVID when this is happening, and of course, it has been a long time, but we have not avoided coming forward to you. We did not wait until she had expired to come forward. She still can be extended. And so, Judge, I would just ask that clearly Ms. Villano has some addiction issues, but those issues, she is still good to the public, Judge. She still has a lot to offer. She's very young, and those issues are not going to be resolved in jail. So I would ask, instead of revoking and throwing away Ms. Villano for a year, which is not going to do anyone any good, why don't we put her on scram? That way we cannot miss any more blows, and send her to some outpatient intensive treatment services. Send her, like, let's get Miss Villano some services before, we conclude that she should be revoked, because even though this is her 3rd MTR in front of Judge White, Judge, I mean, this really is her second time in front of you. And so I would ask for that to be taken into consideration before we revoke Ms. Villano, because we have not gone through everything with her, so to speak. We have not explored all of the options and services that could be afforded to her before, revocation is the last straw. And I would respectfully ask that we consider alternatives before we sentence Ms. Villano to the Bexar County Jail.
Let me ask you this. She was, I don't have it in front of me, but if I were guessing, she was probably ordered to go to an outpatient drug alcohol rehabilitation program initially, was she not?
I don't recall that, Judge. I don't remember her being required to go.
Somebody that goes on probation for DWI in our court gets ordered to go to some sort of outpatient drug alcohol treatment. She apparently was living in the county at the time. Does that sound right? Was she living in San Antonio or Travis County at the time of this plea?
Travis, I believe, Judge.
We transferred the probation to Travis County, is my understanding. Does that sound right? Ms.
Yes.
Gross, was she ordered to go to an outpatient drug alcohol course initially?
Yes,
Which one was she ordered to go to?
I'm double checking that for you right now, Your Honor.
Under what we call CATSNP, Community Alliance for Traffic Safety New Intervention Program, outpatient in San Antonio. But if she were out of county, I would have said either that course or the equivalent in Travis County or wherever she actually lived.
All right, Judge, she was ordered to CATSNP. And I believe I have a completion certificate for that.
And in that case, Judge, what's the next? I mean, how about intensive outpatient services? Let's get her some help. She has a drinking problem, Judge. I don't think that we just need to throw away the key. I think that there are some steps. There are still ways that Ms. Villano can redeem herself.
Okay, the only options I have left are inpatient drug alcohol rehabilitation at the substance abuse treatment facility, which would be a minimum time span of 120 days. I could order to 180 days, but no use in me ordering her there and then picking her up and forcefully taking her there if she's not going to listen to them. You keep telling us that she wants to rehabilitate. She has an addiction problem. The only way to address an addiction problem as severe as the one that Ms. Villano has with alcohol is to change the way she thinks about alcohol. And the only way to do that, if possible even then, is an inpatient drug alcohol rehab. Ms. Gross, am I stating what you and I have experienced for the last 30 years correctly, or do you have another idea? Here's where we're at. Ms. Warburton wants to do outpatient. She's already done outpatient and it's not helping. That's our problem. You have to turn your microphone on, Susan. Thank you.
Yes, Judge, and the only other problem that we have is that the 2-year probation mark would be in April of next year, and that would not give us enough time to send her to residential.
But we could extend her if we wanted to, could we not?
She could be extended by the statute, is my understanding, Judge. There is still enough time for Ms. Villano to go to residential.
Bottom line is, if she wants to volunteer to go to SAT, Substance Abuse Treatment Facility in Bexar County, then we have something to talk about. If she doesn't want to volunteer, then I'm just left with a jail sentence. I don't have any other options to present her. Do you want to go into a chat room and chat with her about those two options?
No, I volunteer. I deal with depression. That's also another reason why I train.
Well, everybody gets depressed when they get sent to inpatient drug alcohol rehab. There's no doubt about that. But that's the only tool for you. Go ahead, Alice, go ahead.
I mean, I think I've heard it from Ms. Villano that she would like help, Judge. I don't think she just wants to go to jail. I think that she would prefer help. And I think that's very admirable considering that, you know, even at 365 days in jail with the way they're doing time served or the way they're counting time, I think that, you know, that's admirable.
Okay, I still haven't received an answer from y'all, and maybe y'all need to chat in private before you give me an answer. Her two options are this. She can volunteer to go inpatient for 120 days. She will probably have to go to the Bexar County Jail for what, 2 weeks plus or minus, Susan?
Probably a little bit longer because they have to do the medical after they get back a clean COVID test.
Okay.
Why don't we go to a chat room?
Pat, can you send them to a chat room and then they can come back in when they're ready to come back in?
Yes, or I'll put them in a chat room. Y'all can go back to one. Alice, Alice, both you and Miss, I don't know, we're in one. Y'all can go back to one. Ms. Villano, you should be able to go back to one. There you go.
Okay, let's go back on the record on clause 627244, State of Texas versus Joseph Philip Olivares. Mr. Lopez and Mr. Olivares went into a chat room to go over the documents and I guess have their consultation about what to do in this case. Mr. Lopez, what did y'all decide y'all want to do?
I don't know where Mr. Lopez is, sir.
I just saw him a minute ago. Did we lose him again? Do we have Mr. Olivares either? Maybe I'm hallucinating.
I sent Mr. Lopez the documents twice in the last 10 minutes and he keeps telling
Mr.
me.
Lopez and his client are in, Mr. Lopez and his client are in a breakout room.
And he keeps telling me I'm sending him the wrong documents and I'm not.
That's fine. We'll go to the next one and then we'll come back to that.
Okay, all right.
Let's see, we've got Ms. Benavides and we've got Mr. Zaborowski. This is cause number 263955, State of Texas versus Gary G. Zaborowski II. This is a motion to revoke community supervision. Representing Mr. Zaborowski is going to be himself, pro se. Is that correct, Mr. Zaborowski?
Yes, Your Honor.
Okay. And the court has assigned Miss Alma Benavides as standby counsel to answer any questions Mr. Zaborowski might have with regard to procedure, et cetera. Is that correct, Ms. Benavides?
Yes, it is, Your Honor.
And Mr. Zaborowski, the first document I'm going to ask you to identify is entitled Defendant's Consent to MTR Hearing by Video Conference. And I assume that you have signed both in the defendant's signature slot and in the attorney's signature slot. Is that correct, sir?
True, Your Honor.
And Ms. Benavides, your signature is not on this document. Is that correct?
That's correct, Judge.
Okay. But Mr. Zaborowski, it is clear from this document that you do consent to having an MTR hearing by video conference. Is that true?
Yes, Your Honor.
Thank you, sir. The next document I have in front of me is entitled Trial Court Certification of Defendant's Right of Appeal. And the document copy I have is not marked at all, but it should be marked as a revocation of the defendant's community supervision. And the defendant has a right to appeal the court's actions revoking the community supervision, but not the underlying conviction. The copy of the document I have does have Mr. Zaborowski's signature under defendant. It does not have a signature under defendant's counsel. It has a spot down the bottom that says Alma Benavides standby counsel. Mr. Zaborowski, did you sign this? I guess where it says defendant?
Yes, Your Honor.
And did you intend to sign it where it says defendant's counsel because you're representing yourself also?
It didn't give me the option to do that, Your Honor.
I'm sorry, sir, say that one more time.
It didn't give me the option on Adobe to sign in that area.
Oh, I understand. Okay. Well, when this is all over and said and done, I assume that you'd be happy to sign that if we can make that available to you, would you not?
Yes, Your Honor.
All good. The next document I have is entitled Waiver of Counsel by Pro Se Defendant, which states, I have been advised this 13th day of November 2020 by the court of my right to counsel and trial of the charge pending against me. I have been further advised that if I am financially unable to employ counsel, one will be appointed for me free of charge. Understanding this, I wish to waive the right and request the court to allow me to proceed with my case without any attorney being appointed for me. I hereby give up my right to counsel. And dated 11/13/20. Apparently, this is your signature on this document, is it not, sir?
Yes, Your Honor.
Okay, and I don't know that I was provided this document, but the copy I have does not have my signature on it, but I'm certainly happy to sign it. Original, if it's not been signed, I will sign it after this hearing. Okay. An uncontested motion to revoke probation, but it's my understanding that Mr. Zaborowski has provided mitigation in the form of two documents that I think both the state and I received. And one is entitled Acala Mexican Restaurant, 606 West Avenue, San Antonio, Texas, 78201. R.E. Gary Zaborowski, referenced by County Court 6. And it's signed, it's a one-page document signed by, and it looks like, is it Lucille?
Yes, sir.
Owner, oh, there, Lucille Hooker. Does that sound right?
Yes, Your Honor.
Normally in these cases, Mr. Zaborowski, this document would be considered hearsay. If the state were to object to it, it wouldn't come into evidence. I had a previous conversation with, I think, Mr. Maru on this case, who said the state was not going to object to these documents coming in. Is that still a current state position, Mr. Wright?
That's correct, Judge.
Okay. So I read that document. I assume the state's read that document. Ms. Benavides, have you read that document?
Yes, Your Honor, I have.
And the second document I have is dated November 12, 2020, and this appears to be a personal statement from Mr. Zaborowski. It does not have a signature, but it's got his name at the bottom, Gary G. Zaborowski. Is this your document also, Mr. Zaborowski?
Yes, Your Honor.
For purposes of the record, I'm going to label the first document from Acala Mexican Restaurant and the statement of Hooker as Defense Exhibit 1. And I will assume that the defense wants it admitted. So the defense has moved to admit this document, and it's my understanding the state has no objection. Is that correct, state?
Yes, Judge.
It shall be admitted. And the second document, which is Mr. Zaborowski's personal statement, I'm going to mark as Defense Exhibit 2. And I also assume that Mr. Zaborowski wants this into evidence. And therefore, we're going to say that the defense is asking that Defense Exhibit 2 for identification be admitted into evidence. State any objection to Defense Exhibit 2?
No, Judge.
It shall be admitted. So both these documents are admitted, and everyone has read them before. If they want to read them again, they're welcome to do so. Are there any other documents that y'all wanted to provide, Mr. Zaborowski? I just have the two, I think. I did not hear your answer, sir. I apologize. Okay.
Oh, no, Your Honor.
Okay. All right. So we're to the point where on the motion to revoke community supervision, Mr. Zaborowski, how do you plead, sir?
True.
Is that true? Is that correct, sir?
Excuse me, Your Honor?
Are you pleading true? That
Yes,
these
Your Honor.
allegations are true? And I assume that you have an explanation that you'll be happy to give us. Is that correct?
So yes, my previous attorney had written an explanation that when I left probation in 2011, that I was homeless.
Hey, sir, Mrs. Obrowski, I apologize. Let me interrupt you there. You're going to get a chance to tell me all that in a minute, but right now I'd like Ms. Gross to tell everybody, including you, what the probation department's position is on the status of your probation. So Ms. Gross, would you go ahead and advise us all of that?
Yes, Your Honor. Mr. Zaborowski has performed very poorly on probation in that he never reported. He was placed on probation on October the 7th of 2010, and he never made it from the courthouse to the probation department to sign his documents. He has never paid anything. He has a balance of $24,267.66 balance. Never made a payment, and $23,323.66 is restitution owed to his victims. He did not complete any of his 80 hours of community service, and he did get arrested for a new theft of property less than $1,500 in Houston, Texas. And as for priors, he has a theft under $1,500 enhancement and 4 prior theft 50 to 500s that I believe were rolled into this case at the time. The probation department is recommending revocation, as this case is 8 years old and expired on October the 6th of 2012.
Okay, Mr. Zabrowski, go ahead and tell us your side of the story, please, sir.
Yes, Your Honor. So first of all, my case out of Harris County was charged in 2012. It's a hearsay case, Your Honor. There is no proof on that case, so I don't, I mean, there is a case against me, but there is no proof on that case. So I presume that.
You're going to have to start over. I can't hear anything you're saying.
Hello?
Yes.
Oh, okay. Are you hearing me now?
Barely.
Okay.
That's good.
Okay. So I was put on probation in 2011 for the checks that I had written in 2007, 2008. When I was put on probation, Your Honor, I did not have any place to go. I was homeless. I did return to Houston to stay at the Salvation Army for several months while I tried to find employment. And then I came back to San Antonio in 2013. At that point, I had met my wife, who I'm married to today. And for the last 7 years, we've been married, or last 6 years, we've been married. And I've tried to regrow my life from things that happened before. I am currently working at Toyota. I have the opportunity to now pay back everything that I can put on I know that I can't be put back on the same probation, but I'm asking if I could be put on a new probation in order to pay back the restitution that I owe. I believe that I do owe that, and I believe that that should be paid back. As a character reference, Mrs. Hooker let y'all know how, that I was an important part of her restaurant during the time that I was there. And I plan on being that same employee for Toyota from here forward. That being said, I also have children I pay child support to every month, and being revoked back to Bexar County would prohibit me from paying the child support, as well as I help them in their everyday activities for school. They study at home.
Okay, Mr. Zabrowski, about 2 weeks ago, plus or minus, I think I gave you all continuance for 10 days because you and your attorney at that time had requested time to see if you could raise some money to attempt to pay either the full restitution or an amount of the restitution. Were you able to do anything in that regard during that time frame?
At this point, no, Your Honor, but I am still working, so I can come up with money. Unfortunately, my attorney quit my case the day after the hearing for whatever reason he gave. So I had no other choice but to represent myself in this case.
You're telling me that you're still willing to pay this debt off, but I mean, at the amount of money you're making at your current job position, how long is it going to take you to pay off a debt of $23,000 plus?
The way I saw it is, if I paid $100 a week, I'd have it paid off in almost.
You're gonna have to talk up. I can't hear you.
I figured the math. If I paid $100 a week, Your Honor, I'd have it paid off in less than 5 years. Which is doable with them, what I'm making now and being able to pay my child support, $100 a week to probation. I'd be able to have it all paid off within 5 years.
It's been 10 years, best I can tell, since you first went on probation and then never showed up at the probation department. Does that sound right?
Yes, sir. And a lot of that had to do with fear. I mean, I'm going to be honest with you, Your Honor. Once I got to the point where I was stable again and I got remarried and we got a house, it was out of fear that I just didn't turn myself in, fear of losing what I was slowly but surely trying to regain. And I just started, within the last, let's say 5 years, rekindling a relationship with my children who live with their mother. So, I mean, this has all been out of fear that I haven't come forward beforehand.
How many children do you have and how old are they?
I have 2 children. I have a 17-year-old daughter and a 14-year-old son.
And during the 10 years since you went on probation but didn't apparently show up for orientation, how much money did you pay on your restitution payments on this case?
I haven't paid none yet, none, Your Honor. As I said, I was fearful to turn myself in just out of fear of what was going to happen to me at that time.
Are you currently paying child support on your children's situation?
Yes, sir, I am.
How much is that?
It's $162 a week.
You say you have 6 children, is that correct?
No, Your Honor, I have 2 children.
2 children, okay. Thank you.
I don't know where the other 4 are.
And that's right, I apologize. I neglected to swear you in before you gave your testimony, so I'm going to do this at this time with your permission and let you say that everything you said today, you mean under oath. So raise your right hand, sir. You swear the testimony you're about to give or have given already are the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir, I do.
And the previous testimony that you gave on your behalf, you would consider to be under oath at this time, and it was still all true and correct. Is that true?
Yes, sir.
Thank you, sir, and I apologize that I missed that. You have anything further to say? I'm going to ask the state if they have any questions for you at this time.
Not just that I see that other people, like for the first time I was in court with you guys, and the second time that I've seen other people have been put back on probation and given that second chance to do right. And now that I'm at the point in my life where I'm married and I have a good job and I'm doing the right thing, I have the opportunity to do right. As I said before, I never turned myself in before out of just plain old fear of what could happen to me, of maybe being able to lose what I have gained so far. But I underestimated my children, my wife, who are sticking with me through all this. And I just want to pay back my debt to society, to the people who I took from. I want to pay it all back, and I believe I can, Your Honor.
State, do you have any questions, or Mr. Zaborowski?
No questions, Judge, but we are happy to see that he's willing to pay back, even though it's an enormous amount of money. We would just recommend that if he is able to pay it back, that he just be given a JSAT, but we would want him to pay back the restitution that he owes.
Susan, what was the original fine amount on Mr. Zaborowski's case back in 2010, I think?
1 second, Judge. I got that right here.
And do we all agree this is a Class A misdemeanor theft, 500 to 1,500 by check?
Yes.
Judge, he was not assessed a fine at the original placement of probation. He only had court costs and supervisory fees and the restitution.
I see a $4,000 fine. I see he was given 1/2, $4,000 fine.
Let me look on his application because it never made it onto his conditions. Hang on.
You recall, Mr. Zaborowski, whether you were assessed the fine on this case or not at the time that you entered a plea?
Judge, it
From
was
2 weeks ago, I
it was
believe
probated.
my attorney said that there was a $4,000 fine and or $300 in fines and $400 or $4,000 in something or another.
Judge, there was a $4,000 fine, but the whole thing was probated.
All right, Mr. Zaborowski, anything further from your side? I've lost Mr. Zaborowski.
I don't think he's even in here.
Yeah, he's totally gone, Your Honor.
He's gone, Your Honor. I don't know what happened. Here he is. Here he is. I'm admitting him back in. Okay, he's coming on. He's coming.
Can you hear us now, Mr. Zaborowski? You're gonna have to turn your microphone on, sir. The dang thing automatically turns off on you.
Yeah, I don't know what happened. It fell off.
No problem. Mr. Zaborowski, do you have anything further to add to your case before I rule?
No, Your Honor, just like I want to do right. I mean, after all these years, I finally want to do right because I want to continue doing right.
Do you have any other questions for Ms. Benavides at this time?
No, Your Honor.
Mr. Zaborowski, the court accepts your plea of true to all conditions on the motion to revoke probation with an explanation. I grant the state's motion to revoke your probation. I sentence you to a year in the Bexar County Jail, assess a $4,000 fine plus court costs, actually $0 fine plus court costs because it was probated. Credit for time served, time and money to run concurrent. You're to report to the Bexar County Jail at 9:00 a.m. in the morning on Monday, November 23rd, 2020 to do your sentence. If at any time during your sentence you are able to pay in full the restitution that you owe, which on my sheet is $23,323.66, I'll be happy to waive the remaining jail sentence. Anything further from the state or the defense on Mr. Zaborowski?
May I speak, Your Honor?
Sure, of course.
Okay. Would it be possible, and I'm just asking this because I'd like to give like sufficient notice to Toyota as well as this Thanksgiving I have my children for this Thanksgiving this year. If I'd be able to turn my shift in on the 30th of this month, so I'd be able to give proper notice to Toyota as well as spend a last holiday with my children since I do have them for this Thanksgiving. I didn't have them last Thanksgiving.
I'm sorry, sir. I apologize it's that way, but it's that way. That's your sentence. You report on Monday. If it causes you misfortune, I apologize it's that way, but I only have so many cards I can play. We've had 10 years to try to get this figured out, so I'm out of time.
Yes, sir.
Best of luck to you, sir.
Thank you, sir. Thank you.
Zaborowski.
Nothing further, Judge.
Thank you, Ms. Benavides.
No, Your Honor.
Okay, who's back from the chat room? Let's see. We got Ms. Milano back. And we have Ms. Warburton back. We're good. Back on the record on 586-927 State of Texas versus Amanda Villano. Ms. Warburton, what is y'all's position with regard to either electing to go to inpatient rehabilitation and stay on probation or be sentenced?
Your Honor, after speaking with my client and after being very graciously informed by Your Honor that am I correct that SATIF must be 120 days? It is not 60 or 90.
It's a minimum of 120 and a maximum 180, I think. Ms. Gross, is that accurate?
Yes, Your Honor.
And in that case, Your Honor, confronted with those two choices and given that Ms. Villano does have, I think, 18 days credit for time served. If we count the 10 that she spent in Los Fresnos recently, I think that my client would prefer to be sentenced by Your Honor today. And I do believe that she is $1,200 behind, Judge. And so as a last ditch effort, mercy for the court, if she were to be able to produce that some in 48 hours, we would ask that you terminate her unsatisfactorily.
Hey, and I apologize, we've been going back and forth with different cases. Did I ask your recommendation on this case yet, State?
I don't think so.
Let me ask now, how's that?
Our recommendation would be status on this case. I think it would be helpful for the defendant to get treatment.
And Ms. Gross, can you tell me what Ms. Villano's original fine amount was on her case?
Yes, Your Honor. 1 second here. Her original fine was $800.
Ms. Villano, the court accepts your plea of true with an explanation to condition 2A on the motion to revoke probation. I grant the state's motion to revoke your probation pursuant to your request. I sentence you to 180 days in the Bexar County Jail instead of the 1 year I could have sentenced you to because you did some things. An $800 fine plus court costs, credit for time served, time and money to run concurrent. You're to report to the Bexar County Jail at 9:00 a.m. on Monday, the 23rd of November, 2020 to start serving your sentence. If you change your mind between now and Monday, you decide you want to go into inpatient rehab, let your lawyer know. She's got my cell number. You can call me 24 hours a day, and we'll make arrangements to do it that way. But that's going to be her choice.
And Your Honor, could you put on the judgment, be sure that it is her credit for time served, it is whatever your bailiffs have plus 10. She spent 10 days in Los Fresnos, which city, it would have been, I believe, Cameron County Jail, just very recently. She was held for 10 days.
I'll be happy to.
Your Honor, and Ms. Warburger, you are going to have to find out the days. They will not credit her unless they have the day she was arrested and the day that she was released from the other county. And that's something you're going to have to get for her.
Do you have that information already, Ms. Villano?
I do. I do have the papers at home. Yeah.
Okay, can you send that to me right now so that I can forward it to Pat and she can forward it to Judge? It's very important if you want to get credit for those 10 days that we get that information now so that His Honor can put that in your final judgment. So send it to me right now. Text me a picture.
On her order, I will go ahead and order. She gets 12 days credit for time served. Whether they'll honor that or not, I don't know. But I'll be happy to order it because I believe every word y'all say that she spent that much time in jail. No problem.
Thank you, Judge.
According to Pat, who knows more than I about
Yeah, just get it to me, Alice, and then I can give it to the clerks to add on to it, okay?
Yes, ma'am.
Okay, good luck, Ms. Villano, and thank you, Ms. Warburton.
Thank you, Judge. May I be excused, Your Honor?
Of course.
Thank you.
And we don't have Ray back, I guess. Yeah. Okay. Let's go with Mr. Rodriguez. We've got
No, Your Honor.
we don't have Mr. Rodriguez?
We have Mr. Rodriguez and Ms. Vanis. Okay.
Yeah, hang on. And we've got there's Mr. Hernandez. Well done. All right, this is cause number 406-744 and 469-635. State of Texas versus Oscar Valdemar Rodriguez. Either or both. Motions to revoke community supervision. Let me double check, make sure.
We approached the court before we move forward on this, Judge. I was in the middle of speaking to the ADA when you came onto the bench.
Well, that's because this hearing was supposed to start at 2 o'clock and everybody wanted to talk to the DA at the last minute that y'all should have talked before. Does that sound more or less accurate?
Well, I mean, attempts were made, an email was sent. I didn't hear from anybody other than Ms. Gross. Secondly, I don't think I've been appointed to his second case that's on an MTR. I've notified that as well. But before we move forward, I'd like the opportunity to, with the DA, to speak to you and at least conclude my conversations with the ADA.
You want to be appointed to the second case if you're not actually physically appointed at this time?
Absolutely.
Okay, well, you're appointed, no problem there. Any deal or agreement that you make with the DA, you're well aware that I do not have to follow, is that correct?
Yeah, true, but there is no deal yet. We haven't even gotten that far.
Judge, he has 2 new cases. And he has 2 MTRs and then 2 new cases that are pending.
Okay. Pat?
Yes, Your Honor.
Do you want to get another hearing time frame? This is going to take Mr. Hernandez some time. Would you agree, Mr.
The next one, because of the holiday, would be November 30th.
Can't we make a special one somewhere? Or like,
Your Honor.
Let me talk, please. This Thursday when we have please, can't we reset it then?
Your Honor, you're the one who said you did not want anybody. We could schedule him for next Monday.
We don't have something set for this Thursday for please?
Excuse me, I can't hear you, Judge.
Today's Monday. Tuesday,
Yes.
Wednesday, Thursday. Don't we have a please setting on Thursday afternoon at 2 o'clock?
Yes,
All
Your
right.
Honor.
Mr. Hernandez, would that not be a better time frame than right now for you?
Yes, Your Honor, that'll be appreciated. Thank you.
Let's just reset these cases so that Mr. Hernandez can confer with the state, and we'll take it up at 2 o'clock on Thursday afternoon, the 19th. All right?
Yes, sir.
All right, fair enough. Y'all are going to be excused, and we need Jeff on some other cases, Mr. Hernandez. He can give you a cell phone number or whatever number he wants you to call him at, and y'all can get together anytime after we finish with these other hearings today. Fair enough?
Fair enough. Thank you so much.
Thank you, sir. Good luck,
I'll
Mr.
send you the new Zoom invite.
Okay, man. Am I okay to leave the app?
You're fine.
Thank you, guys. Y'all have a good one.
Okay, and we got Ms. Vanis and Ms. Trevino with us today.
Yes, Judge, I am right here.
Got clause 38365,
Yes.
State of Texas versus Mary Vanis, and this is, stand by, a first amended motion to enter adjudication of guilt and revoke community supervision. Ms. Vanis, I have 2 documents I need you to identify for me. The first one is entitled Defendant's Consent to MTR Hearing by Video Conference, which records your signature and your attorney's signature on it. Is this your signature on this document, ma'am?
Yes.
Thank you, ma'am. And also, for purposes of the record, where Ms. Vanis' name is supposed to be, where it says, I blank hereby waive my right to enter my plea of true not, I have number 6 and B as in Bravo in that blank. The computer must have botched that up. So Ms. Vanis' name needs to be entered in there. Mr. Vino, is that your signature on this document, ma'am?
Yes, Your Honor.
Thank you. The next document is entitled Trial Court Certification of Defendant's Right of Appeal, which is marked as an adjudication of guilt following a deferred adjudication, and the defendant has a limited right of appeal. Is this your signature on this document, Ms. Vanis?
Yes.
Is this your signature as attorney for Ms. Vanis?
Yes, Your Honor.
My record reflects this is an uncontested motion to revoke probation on the first amended motion to enter adjudication of guilt and revoke community supervision. How does the defendant plead?
True.
And what's the status of Ms. Vanis' probation, please, Ms. Gross?
Judge, Ms. Vanis has performed very poorly on probation. She was placed on probation March 7th of 2012. She reported in person on April 30th of 2012. We have not seen her up until she was in jail on October 27th of 2020. She only reported one time. She has made no effort to make any payments and has a balance of $1,037. She has made no effort to complete any of her 24 hours of community service, and we have not received proof of enrollment or completion of her shoplifting class. We have no new or old drug tests on file. Her criminal history includes theft 20 to 200, shoplifting times 2, theft 50 to 500, which is this case, a failure to ID, And she has a new arrest and criminal charge for theft of 100 to 750 pending. The probation department is recommending revocation. This is her first violation report, first motion to revoke, and the case did expire September 7th of 2012.
Mr. Vino, what are you requesting?
I'm requesting a continuation, Your Honor. I've had no opportunity to talk to my client. Your Honor, I got notice about this case on November 10th at 9:12 from Mary Angie Garcia, the Bexar County District Clerk. It had notice for this court date, the case number, and Ms. Venice last name. There was no accompanying paperwork. Nothing identifying her case, her contact information, other than the court rooming and the body of the arraignment notice, there was nothing else. I called Mr. Maroon this morning. He himself, I don't mean to speak for him, but he himself did not know what the case was about and had also not received any paperwork. When I finally spoke to Ms. Gross this afternoon, she tells me it's a 8-year-old case. I would like to have an opportunity to review with Venice her case, find out if there's any underlying problems, and then submit the paperwork for Your Honor to consider. I believe a case that is 8 years old, trying to revoke her and trying to send her back to jail or TDC or wherever they're recommending that they do is unfair, considering that it is an 8-year-old case that has just sat there.
All right, Mr. Vino, let me stop you there. How about we reset you guys for this coming Thursday, the 19th at 2 o'clock, and that gives you plenty of time to get it all figured out. Will that work for you?
Yes, Your Honor. If somebody could please send me Ms. Venice contact information, I'd be glad to do that.
Ms. Venice, do you want to go ahead and give your attorney your cell phone number or your telephone number?
Certainly. Certainly, sir. Mr. Vino, my number is 210-383-9167.
Okay, 283-9167.
No, 383.
383.
Right.
9167.
Right.
Email address, Ms. Venice?
Okay, I will be in contact with her, Your Honor, and we'll be back in court on November 9th.
Okay.
I'm sorry, on Thursday.
Yeah.
The Zoom sign-in information is going to be exactly the same as what you used today. Is that correct, Pat?
Yes, Your Honor.
Okay. And we'll see y'all at 2 o'clock on Thursday, the 19th in 3 days. So y'all take care.
19th. Thank you, sir.
Right. Let's see. Back on 627-244 State of Texas. Joseph Philip Olivares. Ray, were you able to get your questions answered?
Yeah, I was able to confer with my client judge. I would like to confer with the DA. As I stated, he's got two new number ones out of your court, Judge, and we want to see if there's anything we can work out that could take care of everything.
Appreciate you guys for Thursday to give you plenty of time to do that. I don't want to rush you. Would that be better for you?
Thursday?
Thursday. Today's Monday. Tuesday, Wednesday,
Right.
Thursday. The 19th.
Would that be in the afternoon, Judge?
2 o'clock.
2 o'clock. 2 o'clock.
Sure, I have a CPS hearing, but I can come right after that. It's done. It's currently set at 2. I'll work around it, Judge. I'll find a way to be here.
I appreciate it. Just stay in contact with Pat on what you need to do on your other schedule. And Jeff, do you have contact information? Ray, do you have contact information for Jeff so y'all can chat?
I'm sure I have his email address, yes.
You want a cell phone number?
I believe I have that too, Judge.
It's written on bathroom walls all over the bars. A good time call, Jeff. That.
I think I have his information, Judge.
All right. We'll see you guys on Thursday then. Thanks very much.
Okay. Thanks.
Okay.
Okay. Who else do we have still on board with us? Is this Mr.